Last week's deadly violence and lootings in Gauteng and KwaZulu-Natal have created great challenges for many businesses. In fact, as it is, many have already incurred significant setbacks in an economy struggling to withstand the impact of the coronavirus. Footage of many who took part in the thuggery activities of last week is readily available. This raises the question, can an employer discipline and potentially dismiss an employee who is shown to have participated in lootings and destruction of property? Associate Designate in Employment Law at Cliffe, Dekker, Hofmeyr, Kgodisho, Phashe joins us now to answer that question. Kgodisho, good evening, and thank you so much for your time tonight. Let's talk then about this complicated matter that if you're seeing, in footage looting, so where available footage shows employees involved in criminal activities, can this then give the employer the leg to stand on in taking action against such individuals?
Good evening, Bongiwe, and good evening to the viewers. Well, Bongiwe, in general, the private lives of employees are no concern of the employers. Employers, therefore, have no right to dictate the conduct of employees outside of working hours and outside of the workplace. However, there's an exception, and in this instance, where we had civil unrest and various unlawful conduct, that may be an exception if such misconduct can be linked back to one's employer. So yeah, that's where we are right now. So,
in practical terms, are you then saying that if there's nothing linking the employee to the employer during a process of looting, then the employer cannot do anything about this?
Well, to justify disciplinary action for an employee's extramural conduct out of the workplace, the onus rests on the employee to establish the following: that there was a sufficient legitimate interest in an employee's conduct outside of working place, and that such conduct affects the employment relationship. So the most important thing to look at is whether the employment relationship will be affected. So if the answer to that is no, then the answer to that will be there is no, you haven't established the onus to charge such an employee.
I'm going to put you on the spot here and say, I'm coming to you. My employer wants to get rid of me, and I was caught looting in one of the townships. What would you be arguing for me in order to ensure then that there is no link, as you say, and even how unlawful it may have been, or even affecting the company's reputation? What grounds would you then be arguing for such an employee to be scot-free?
Yeah, so in such an instance, we'll look at, again, at the very same two principles that I just referred to, whether there's a link. And if there is no link, for example, there is no sufficient legitimate prejudice that your employer suffered, then it's very difficult to kind of state that there was indeed a discharge of that onus. However, something else to consider is in employment relationships, a very important element is an element of trust. Where the relationship of trust between an employer and an employee is undermined or diminished significantly, that can also be reasons that an employee may be charged and subsequently dismissed.
So in other words, the employer will not trust an employee who was caught looting because they may not know if they themselves may not vandalize their business in future.
Yeah, and in many instances we see this principle of trust coming in. And an example could be, for instance, if you employ a security guard and there's video footage of that security guard taking part in various acts of misconduct such as theft and so forth, that relationship of trust is significantly diminished, and there's no way it may be repaired in the ordinary course of things.
And let's talk about the role of social media here. What role does it play?
Yeah, and that's a very important question. Social media, as it stands currently, has undoubtedly put people's lives in the public eye, and employees must be aware of such that their conduct on various social media platforms can be linked to the employers, and if that conduct in any way tarnishes the reputation and good name of the employer, then there may be dire consequences for that employee. Because something important to consider is that in our day and age, most businesses' profitability and their reputation is based on their online presence and social media presence and other factors surrounding that. So social media and the general media is where most people get the information on, and this includes information on specific businesses. So when we have social media, or when we have employees that put or publish certain content on their social media that may tarnish the good name of their employers, that may result in dire consequences for those employees.
So what recourse then is available for an employee who may have been dismissed, but the company was not able to prove the considerations that you've just put then that they should have taken?
Well, in a good principle in our law is one that let the other side be heard, and this main principle has to be met by the employer. So the employer has to have a fair disciplinary process, and that should be based on that employer's disciplinary procedure and policy. And should such a disciplinary hearing not take place in accordance with that policy, then such an aggrieved employee may take such a matter forward to the CCMA.
All right. Kgodisho, thank you so much for your time tonight. We certainly do appreciate it. That was Kgodisho Phashe, who's an associate designate in employment law at Cliffe, Dekker, Hofmeyr. You heard there some of the then considerations that employers will need to take into account before they dismiss some of those that they may have seen on footage looting.